Hello and welcome to the 35th episode of Business Litigation TV. I'm your host, Jesse David Eisenberg, and this is the internet's most passionate show about business litigation. As you know, I'm a business litigation attorney in New York City, and so what I do mostly is sue on breach of contract. Now, I just did an episode recently explaining basic contract terms, so now I'm going to ramp it up a little bit and we're going to explain basic contract provisions, just so you know what to look out for and what some of the language in your contract is going to mean. So the first one I almost always recommend is an attorney's fees provision. And basically this just says something along the lines of, if there's a lawsuit over this contract, the winning, or as it's usually said, the prevailing party will receive their attorney's fees. Now, this is a double-edged sword, okay? So in New York, you only get your attorney's fees if there's a contract that says so, or if there's a statute. So 90% of the time, if you want a lawsuit, you still have to pay your own attorney. So that's why I recommend you put an attorney fee provision in your contract. However, like I said, it's a double-edged sword, because if you lose a lawsuit, the other side can get their attorney's fees, and you end up paying for that. So just keep that in mind. Another one I see quite often is an arbitration clause, mandatory arbitration, which basically says before a lawsuit can be initiated, the sides have to go to arbitration. Now, arbitration can be expensive, but it can also be a lot quicker than going and doing a full-on lawsuit. But I'd say 90% of the time, prevent a lawsuit if that's the route you'd rather take. So you got to think long and hard if you want that included in your contract or not. The next one is called a choice of law provision. You'll see this quite often, that, let's just say you're a shipping company, you make contracts with people all over the country, all right, but you're based out of New York. You're going to want a choice of law if there's any disputes over your contracts, for the law to be of the state of New York, where you're from. Now, this is also in connection with, there's usually a jurisdiction clause that goes with that, which means that, no matter where the lawsuit or where something happens, or let's say you're a New York shipping company, you're shipping to Oregon. If there's an issue, you're with the contract, you're going to say that they have to come from Oregon to New York to litigate anything. Okay? There are waiver provisions sometimes, which basically says, you're going to give up a certain right. I don't know what that looks like, because it depends on the contract, but let's say, you waive the right to a jury trial, which in business litigation is not that big of a deal, but it's a provision you will see in some contracts. So a waiver is just, you're giving up a right. There's also, and this is much rarer, a statute of limitations clause, which basically can extend or shorten a statute of limitations. Now, the statute of limitations for contracts is 6 years. So maybe you want to shorten it to 3, so you're not looking over your shoulder for an extra 3 years. Something along those lines. All right, usually standard language in a contract includes a severability clause, which says that if there's an issue in the contract, a judge finds that, some provision violates, the law, or just cannot be applied in this case, a severability clause makes the rest of the contract still valid. There's integration clauses, which says that this is the whole deal. There's no outside information that was considered, something along those lines. And you'll see that quite often, because people will say, well, I was induced into the contract, based on this outside information. And sorry if you saw my hand go up, or saying bye to someone. Basically, an integration clause says that, protects you if there's that situation where there's an outside influence. I have a case where they say, well, these marketing materials, are why I signed up, and they didn't perform according to the marketing materials. So what the integration clause then prevents says, listen, this says that no other information was needed or was considered, that this is the entire deal and there's no outside information. And that can, if it's specific enough, that will prevent a lawsuit or end a lawsuit based on any outside information to a contract. Another clause is a limitation on damages clause. And a limitation on damages clause basically says that, the most you can win if we go to court is, a common thing is, the price of the contract. So you can't get anything above and beyond that. There's a liquidated damages clause that you'll see in contracts which says we don't know how much a violation would be, and it's almost impossible to calculate. So we're going to have liquidated damages clause that says that we're going to cap it at 10% of the contract or something like that, or it just would be 10% of the contract or whatever the percentage is. Always look out for your warranties in the contract. They can expressly warrant something, obviously, a certain type of workmanship, a certain type of performance in general. And there's also the opposite clause. So an opposite, that would look like, there is expressly no warranties. We don't give any warranty for the performance. We don't give any warranty for the condition of the supply, something along those lines. Two last clauses I want to talk about. The first one's super simple. Confidentiality. A lot of contracts can have a confidentiality clause, means you can't talk about certain information, and then there's also an indemnity clause. So you'll see this a lot of times in general contractors. If you're hiring a general contractor, you're going to want an indemnity clause that if one of their workers or someone gets injured because of their work, and you get sued, that they're going to cover it. Okay, so that's what an indemnity clause will look like. One side is covering the other if there's a lawsuit by someone else. Okay, guys, if you have any questions, you want further explanation, or if you have a contract term that you'd like discussed, please email me, Jesse, JESSE, @jdelaw.nyc. And lastly, guys, if you're drafting a contract or just signing a contract, please hire an attorney. It can be costly, but you're saving yourself money in the long run if there's any issues, okay? All right, guys, thank you for listening, and as always, take care.